everyone, my name is Geetanjali Singh and I am currently interning at LEXIS and Company, and the topic for today's video is difference between cognizable and non-cognizable offense. Now for the start we must know where these terms lies within. Now the introduction part is the criminal procedural code lays the rules to conduct of proceedings against any person who has committed any offense or wrong under any criminal law, whether it is IPC or any other criminal law. It basically the CRPC classifies the offense under the gravity and nature of an offense, and they can be classified under the three following heads. Number one, bailable or non-bailable offense, cognizable or non-cognizable offense, or compoundable and non-compoundable offense. Now, in this video, we learn about what are cognizable offense and what are non-cognizable offense and the difference between them on the basis of some points of distinction. Now, for the start, a cognizable offense is an offense in which the police officer, as per the first schedule or under any other law, for the time being in force, can arrest the convict without a warrant and can start an investigation without the permission of the court or magistrate. Cognizable offences are generally heinous or serious in nature, such as murder, rape, kidnapping, theft, dowry death, etc. In this, the first information report is registered only in the FIR is only, this is the main confusing part, whether the FIR is registered under cognizable offense or non-cognizable. Mainly the FIR is only registered under cognizable offense and crimes, and under section 154 of CRPC, a police officer is bound to register an FIR in a case of cognizable offense. He can also conduct some kind of primary inquiry before registering the FIR. In these offences, a convict is arrested and produced before the magistrate in the stipulated time. Some of the examples of cognizable offence are waging war, attempting to wage war, abetting the waging of wars against the government of India, murder, rape, dowry death, kidnapping, theft, criminal breach of trust, or unnatural offence that are heinous and serious in nature. Now, section 154 of CRPC provides that under cognizable offence, the police officer has to receive the FIR relating to the cognizable offence. Now, we'll deal what is non-cognizable offence. A non-cognizable offence is the offence listed under the also first schedule of our Indian Penal Code and is bailable in nature. In a case of non-cognizable offence, the police officer cannot arrest the accused without a warrant, as well as cannot start an investigation without the permission of the court. The crimes of are, for example, are forgery, cheating, defamation, public nuisance, etc. falls under the non-cognizable crimes. In this type of crimes, a criminal complaint is lodged with the metropolitan magistrate, who is supposed to order the concerned police station to initiate an investigation. The police officer is supposed to file a charge sheet with the court, which is followed by a trial. After a trial, if the accused is found guilty, the court passes the order to issue the warrant to arrest the accused. Now, some of the examples of non-cognizable offence are assault, cheating, forgery. Difference between is, in cognizable, it is an offense in which a police officer can arrest the convict, as stated earlier in this video, convict without the warrant. But in non-cognizable offense, police cannot arrest an accused or a person without a warrant. In cognizable, a police can start a preliminary investigation without the permission of the court or without registering the FIR, but it does not happen in non-cognizable case. The police officer cannot start the investigation without the permission of the court. Cognizable cases are heinous in crime, whereas non-cognizable are lesser in degree than cognizable. The victim can file FIR or make a complaint to magistrate in cognizable cases. Now, in non-cognizable, the victim can only make a complaint to the magistrate, not the police officer. Cognizable offences is defined in the section 2 subclause C of CRPC 1973, whereas non-cognizable offences are defined under section 2L of our CRPC. In this cognizable offence, the police officer is bound to register FIR even without the permission of the magistrate, whereas the police officer is not bound to register the FIR or cannot register FIR without the prior permission of a magistrate. In cognizable offence, it is a non-bailable offence, whereas non-cognizable offence, it is bailable and sometimes non-bailable offence also. There are some procedure which must be followed under cognizable offence, and there are 13 stages. Number one, FIR, then report to magistrate, investigation, search and production of documents, then arrest, remand, and statement of witnesses, medical examination, then we file charge sheet, then it requires inquiry, then trial, and after that judgment, and then punishment. And the procedure under the non-cognizable offence are, first of all, we must take the police or the complainant must take prior permission of the magistrate, and then all the following procedure under cognizable offence will be followed as usual. Now, while concluding, depending on the severity of the crime, cognizable offence are either bailable or non-bailable in nature, whereas non-cognizable offences are bailable offences. The punishment of non-cognizable offences is imprisonment for less than 3 years or sometimes fine only, whereas cognizable offences attract punishment with the imprisonment for more than 3 years or more, or some, or in some cases and in serious cases it can be given as a death penalty or imprisonment for life also. That was all. Thank you.